Welcome back, everybody, to our session with Kevin Attkisson, a personal injury attorney in the state of Ohio. Kevin, welcome back.
Hi, Michael. Thank you very much.
Thank you. Kevin, you and I mostly talk about car accidents, but full-fledged personal injury attorney, so any type of personal injury, you could represent a client. And of course, a very common one is slip and fall, also known as trip and fall, kind of an incident. Can you tell us, please, what's involved? What are the elements of proving such a case?
Yeah.
What are possible defenses that a landlord or owner of the premises can use? And how do you fight back to get maximum compensation for your clients?
Yes, well, thank you very much. Yes, we do handle a lot of slip and fall cases. Some lawyers don't like to get involved in them because they're difficult. We don't care. We like to fight for people. We like to take on the companies and the insurance companies to make sure that people get fully compensated. Yes, generically, they're called slip and falls, trip and falls. Technically, they're called premises liability cases. That is, you got hurt on somebody's property as opposed to somebody hitting you with their car or doing something to you. You encountered something on somebody's property that was dangerous and caused you to be injured. Typically, these can happen at a store or on like at an apartment complex in a common area, things like that. But let's talk generally about premises liabilities, and let's just say like at a grocery store, you could slip and fall on an item on the floor, a premises liability case. So first of all, you have to establish that there was a dangerous condition. That is, there was something in the store that was dangerous that caused you to be injured. A substance on the floor, something that caused you to trip, something like that, and then you trip, you fall, you get injured. So you have a dangerous condition. What the insurance companies and the defense lawyers look for is was this substance, this item that caused you to fall, was it visible? Was it open and obvious? And then they make an argument like you should have seen it. It was there to be seen. You should have noticed it, looked out for your safety. We make the argument that maybe there were attendant circumstances. You're there shopping. You're looking at things on the shelf. You're not necessarily looking down at the floor. Maybe you're pushing a shopping cart in front of you. You can't see what's on the floor in front of you. And there's an item on the floor that you fall on. What is probably the most important thing, though, is how did that substance get there? And usually you ask your client, how did that? They don't know. Why would they know how it got there? That's why we need to investigate these and find out what happened. A lot of times you can have, let's say you're at a grocery store and there's a cooler leaking and there's water coming from under it. Clearly that's the fault. No customer put that there. It came from the store's own cooler. Maybe there's a leak in the roof that's coming through and water's getting on the floor. Maybe an employee mopped the floor and they didn't put up a sign. Right? So all these things could be the store's fault. Okay, and we want to investigate that so we make sure that we understand, because it's just because you fall on somebody's property doesn't necessarily mean it's their fault. Okay, you have to prove it was their fault, that they caused it, or that the dangerous condition was there and was there. They should have found it. They should have made an inspection. They should be looking out for those things. If it's near the cash register, maybe the cashier should have noticed this thing on the floor if it was there for long enough. So there's all kinds of factors. But I will tell you, the insurance companies and the stores, they fight these cases very, very, very hard. Okay, and so we have to fight hard for our clients to make sure that they're fairly compensated. And we do. We take on these cases where a lot of other lawyers won't, and we do that because we've been very successful with handling premises liability cases.
Yeah, because like you mentioned, these corporations, they fight back hard and they have deep pockets to fight. That's why you have to have an attorney that also has the resources and the knowledge to answer whatever the insurance company or the landlord throws at them. And fight for the best interest of the client.
Absolutely, and we do that. And just to point out here, we don't care who it is. We don't care if it's a big company, a big corporation, a big insurance company. It doesn't matter to us. We fight them all just the same, because our clients deserve to be compensated for what happened to them, and we don't let these companies and insurance companies take advantage. I would like to make a distinction here between, let's say you got hurt at a grocery store or a department store or something like that, as opposed to getting hurt at an apartment complex or something like that. Okay. So the difference there is that in Ohio we have a landlord-tenant statute. Okay.
Mhm.
And that puts additional duties on the landlord to maintain the premises. All right. So they have to maintain the actual apartment unit in a fit and habitable condition. Okay.
I see.
So the unit actually has to be safe, but also the common areas have to be safe as well. Okay. So if you are there and you get hurt, you can make the argument that they violated the statute. Okay. And that's it's a little bit different. There's a distinction there to prove that somebody was just negligent. You prove that they violated the statute, and then you can prove what we call they were negligent per se for violating the statute. Those cases are there's a difference there, and you have to handle them a little bit differently than your typical slip and fall case at a retail store.
And see, Kevin, that only comes from experience, because you actually do these cases, you're able to advise the client, and you're able to see where the landlord was negligible and how you can pursue different avenues of getting compensation for your clients. So
yes, absolutely.
We really appreciate, and this is why we bring you to our sessions, so you can educate the public on what's involved. I just want to ask you a follow-up question. You mentioned that in supermarkets or other public places, you frequently see after somebody mops the floor or something is wet, they put up like a yellow sign, careful wet floor, or in Spanish, piso mojado. I'm just curious, once that's there, that means they're completely absolved of any liability if anything happens, or you think you could still pursue a claim? What do you think?
So obviously, if they're mopping the floor, they're creating what could potentially be a dangerous condition, making it wet, slippery, there's soap, whatever. Their duty, the stores have duties to people coming in as customers. Okay, one of the duties is that this place needs to be safe for them. Okay? If there's a hazardous condition that they created, they need to warn people about it. Okay,
right.
That could satisfy their duty to warn. Now, the sign can't just be a sign; it has to be effective as well. Okay, if I put out a sign and I'm mopping in this particular area, and I'm mopping way over here as well, and I don't move the sign, or I don't put up an additional sign, well, the sign that you put up, it may not be effective. So it has to be an effective warning, not just, oh, I put up a cone and now I'm absolved of any liability.
That makes sense.
So it's a bit of a gray area, and obviously we would like stores to warn people if the floor is wet, but it might not. Again, it has to be effective.
Yeah, Kevin. So I think this is why, and I think you're gonna tell me if I'm wrong. It's very important because these cases are very fact specific, like you said, where the sign was, where the mopping was done. If somebody gets injured, of course, make sure you get the medical treatment first, call 911 if you have to. But I think it's also important to take pictures and maybe a video of your surroundings, right?
Sure.
You can later prove your case.
If you're able to, or if you have somebody with you that can do that, a lot of times if somebody's, depending on the severity of the injury, they might not be in the position to take photographs. But also, you got to remember, most of these stores, your bigger stores, they have cameras all over the place. Now, they don't necessarily share that video with us pre-litigation. But if we get into court, then we can obtain that the videos through discovery. They have an obligation to not willfully destroy relevant evidence, such as videos. We also notify them in writing that they are not to destroy evidence, and they're to preserve all video and other evidence. But one thing at the scene of the incident that can be important is to I guess have witnesses who maybe saw what happened and get their information. Okay. Also, store employees. A lot of times, a store employee will be alerted that somebody fell. They'll come up, they'll see the person there, and they might say something to the person like, "Oh my goodness, I'm sorry, I forgot to put up a wet floor sign," or "Oh my goodness, I meant to clean that up," something like that. And so that could be an admission that they knew that this problem existed and they didn't do anything about it. So that could be important evidence as well that we might want to take note of.
Understood. Okay, Kevin, thank you so much. We appreciate the information you shared with us. Thank you for taking time out of your busy practice to help us understand the elements of proving a slip and fall case. And Again, I want to remind everybody, whatever we talk about today or in any of our videos, that is just general information. That is not legal advice. However, if you want consultation on your specific situation, on your specific injury or incident, we encourage you to call the law offices of Kevin Attkisson. The phone number and the website are on the bottom of the screen. And of course, the consultation is completely free. Thank you, everybody. Thank you, Kevin. And we're going to come back in our next session to car accidents. And we're going to talk about side swipe accidents on the highways of Ohio. Thank you. Have a good day.
Thank you.
Take care.